The government last month introduced new IT rules, which are basically to govern internet and digital media. And this has raised a big controversy because it also directly impacts, according to many experts, the freedom of the press, especially digital media, which is the emerging avenues for news as well. To talk to us about all of this, I am joined by Vivek Sood, who's a senior advocate in the Supreme Court, and he's an expert on IT law and the information technology, the various facets of that. Vivek, great to have you with us. Very often we say that the law takes time to catch up with technology. Here, sometimes people are saying that the law is ahead of technology. Everyone's been put in the same basket. This particular case has gone to the Delhi High Court, and a notice has been issued challenging these rules. Um, it includes three basic entities are covered by this. That's OTT, over the top platforms, the things like Netflix, Amazon Prime, others like internet providers, and lastly and most importantly perhaps are the news services as well, the media agencies. Do you think the government has gone too far to first of all put all of these three entities under this one rule? Vivek.
First of all, thank you, Sidharth, for putting me on this platform. And I must start by saying that, in my view, law will never be able to catch up with technology. So, technology is very fast moving in this world, and law will have to, catch up, and the technology will move ahead and ahead. So, to say that law is ahead of technology today, I don't agree with that, firstly. And secondly, definitely the government has gone overboard, by getting these, internet and digital media ethics rules of 2021. First of all, the definition of intermediaries is well beyond what is defined in the Information Technology Act of 2000. Traditionally across the world, intermediaries are platforms, they are third party enterprises which have nothing to do with content. They are platforms, they are like telephone companies. Telephone companies can never be hauled up for conspiracy, for defamation, for intimidation, because it is people who transmit and who express themselves on these platforms. Now, first of all, the definition of intermediaries in these rules is overbroad. They have included media houses, online portals, entertainment platforms, etc., etc., which are clearly not intermediaries. They are not platforms on which people come and interact. They express themselves. They express themselves, Siddharth. So definitely the government has gone overboard by a very overbroad definition of intermediaries. Firstly,
But Vivek, won't you also concede the argument that there is right now no regulation, and I'm talking about over the top platforms, and that's of course where a lot of entertainment is consumed. So whether it's fiction or it's movies or it's very popular shows. Obviously, there are censorship laws as far as fictional content is concerned. Right now, there is no regulation as far as they are concerned.
okay. So now, traditionally, these the censorship is contrary to Article 19(1)(a) of the Constitution of India. Now, by regulating these platforms, it's a way of introducing censorship. You may not have a regulatory mechanism which is passing the news or entertainment. It is post facto, but it amounts to some kind of censorship. And now you talk about regulation. See, I believe, and the Constitution of India supports me, when I say that the freedom of speech and expression is one of the most significant fundamental rights that we have in part 3 of the Constitution. In my view, it is as important as Article 21, which guarantees the right to life and liberty. So, what is good of life and liberty if I cannot, express myself freely, or if my speech could be chilled? There could be chilling of free speech if I have to think twice before speaking and expressing myself. Then, there's a clear violation of the freedom of speech and expression, in my view.
And do
Now,
you think,
now there's one thing.
yeah,
Regulation is permissible under clause 2 of Article 19. Reasonable restrictions can be imposed, but they have to be extremely narrowly tailored. You can't have something as broad as what I am seeing in these guidelines.
it's exactly, and that's what the worry is. I think no one, and even you, would not disagree with this argument that as far as content in films and shows are concerned, entertainment, there should be at least advisories that this is a content for a certain age group. Like very often films would have certification, above 18, universal audiences. That right now is missing as far as OTT platforms are concerned. But that is as far as they are concerned. What's happened is everyone's gotten clubbed together: OTT, internet service providers, and also very importantly, the news, the media. So a lot of people are now actually consuming news exactly like this online. And that's where, a lot of the news is being covered and generated. Vivek, the Editors Guild has also written to the government saying that according to them, this seriously undermines these rules, the media freedom in India. The code of ethics, as far as this law is concerned, the rules are concerned, stipulates vague conditions such as good taste and decency. Now, the question is, a news item may not obviously favor somebody. So that person may say that, look, you're saying that I have done this, or the news is saying, that these are the facts. It's not in good taste as far as I'm concerned. So then what happens next? I mean, is this basically a way of, will media companies have to think thrice with these new restrictions about covering anything?
Yes. So, I must, speak about 66A. Now, 66A of the Information Technology Act was over broadly defined, and therefore it was challenged. A number of people, innumerable people across the country were unfortunately arrested, under Section 66A. Finally, it met its fate when the Supreme Court in Shreya Singhal struck it down as unconstitutional. Now, these words, good taste, etc., decency, good taste, obscenity, all these words are very susceptible to a very broad interpretation, and it is, they are vulnerable to rope in the innocent men who are merely expressing their views. So, definitely,
And who's going to stand? And who's going to stand in judgment?
If I apply Shreya Singhal to these rules, some of these rules are liable to be struck down as unconstitutional, keeping in view the precedent laid down by the Supreme Court in Shreya Singhal's case.
And also importantly, Vivek, as you said, Article 19 provides freedom of speech, but it's also got reasonable restrictions, and those are the very narrow restrictions which have to be obviously seen in relation to other rights as well. As far as these particular rules are concerned, who's going to sit in judgment and who's going to decide what is decent, what is right, what is wrong? It's not going to be the courts. I guess, government officers can essentially decide that this is, according to that government officer, not good enough. Okay. Is that also a Pandora's box? Because I mean, until now, every Indian who feels that there's a violation of Article 19, that perhaps people have gone too far ahead, can go to the courts. What's going to happen as far as these rules are concerned? Does it now put a lot of power in the hands of the government?
Yes, you are absolutely right. First of all, a simple complaint by an individual can trigger action under these rules. Now, I have a problem with that. Somebody will say this is defamatory, somebody will say this is harmful to minors, somebody will say it hurts my religious feelings, this and that. So how a single complaint can chill the free speech of a large part of the media. I have a problem with that, firstly. Secondly, the problem I have is the manner in which the government will now sit in judgment over the expression of free speech. I have a problem with that. Although, these rules have a three-tier regulatory mechanism. At the first level, the media platform itself will regulate its behavior. Fine. At the second level, the judges of the High Court and Supreme Court, some retired High Court judge or Supreme Court will judge, whether there's a violation of the rules. And at the third level, an oversight committee, an interministerial committee of the government of India will regulate the implementation of these rules. Now, I don't buy this. I don't agree with this. I feel that definitely these rules will have an effect of chilling free speech, across the media. So therefore, the challenge in the Delhi High Court that came up today on behalf of the Foundation of Independent Journalism, in my view, prima facie has a lot of merit. Now, having said this, there has to be some regulation. As I said earlier, the regulation has to be very narrowly tailored. Now, in my view, you can say, okay, we will not permit child pornography. We will not permit xenophobic content. But these terms have to be clearly defined. Sidharth, I have been doing criminal law for 3 decades now, apart from the other areas of my practice. Whenever I pick up the Indian Penal Code of 1860, I find every provision, most of the provision will have illustrations as to the applicability or the inapplicability of the provision. Now, these days, these legislations like the Information Technology Act of 2000, all these rules, I don't find illustrations. And these are broad expressions, there's the taste and obscenity and vulgarity and what is defamatory. There is so much of subjectivity. And one complaint can trigger action, under these rules, which in my view is full of flaws.
And we've seen it even the IT Act 66A that was eventually struck down by the Supreme Court, and that in fact came in from the earlier government. It came in under the UPA regime. Is this perhaps, as many are calling it, similar kind of powers once again branded under a different name? Is that? Would you agree with that? That's what several experts are saying.
I will not, I will not say that this is kind of there is a connectivity between the two. I don't find a connectivity. I find that these rules are independent. Okay. Now I must say this. I must say that I don't see any intent behind these rules. Laws and executive rules are are in my view not made with any intent. So, the government perceives the threat, to the citizens, to the people. They feel that these rules are for the social good, for the larger public interest, to protect minors, to have decency in the society, to have decency in the social media, etc. So I don't feel that, there is some kind of a, UPA intent or a UPA flavor in these rules. I don't find a BJP.
That was UPA. Now we have the NDA. So I'm just saying that.
Yes, so I don't find a BJP flavor, or I don't find this to be political. I find that the government has, in its wisdom, come out with these rules, which in my view, many of the parts of these rules are prima facie or ex facie. They violate Article 19(1)(a), the freedom of speech and expression, and hence they appear to be unconstitutional. Now the matter is sub judice. The courts will decide to what extent, these rules fall foul with the Constitution of India.
And would it be correct to say then what you're saying is that obviously we need some regulation, but in terms of not spelling out exactly what indecency is and other things, it gives a wide sweep of ranging power, and especially when all three entities are being clubbed together, which is also ISPs, intermediaries, OTTs, as well as the media. So perhaps the first two categories, because as far as the media is concerned, media has certain freedoms, rights, and duties. And of course, everyone, all three entities are covered under Indian law.
Yes, I totally agree with you. My foremost objection is the bundling of all these platforms under one umbrella. You can't, they are, in my view, the media that gives the news, that expresses itself through journalists, is not an intermediary. It is not a platform where citizens go and put their blogs. They are not like internet service providers or Google or Facebook. So there is a clear classification between intermediaries and non-intermediaries. The media is a speaker, and whereas the intermediaries are platforms where people speak. So there is a clear line of distinction between the two. So I find that this bundling, is not in accordance with the Information Technology Act, and in my view, they fall foul with the Constitution of India.
Well, absolutely. Vivek Sood saying that as far as these laws are concerned in the present shape and form, they would be in violation of the Constitution and liable to be struck down. And of course, these rules have been challenged in the Delhi High Court, which has issued a notice in this case to the central government to reply. Obviously, that particular case we'll be tracking as well. And well, thanks again, Vivek, for joining us and sharing your expertise and your views on this. We'll be coming back to you again regularly for more on this and other subjects. Thank you so much, Vivek.
Thank you, sir. Thank you.